I'm David Miller, and I've been practicing estate litigation law in California for 18 years. In that time, I've seen cases that would make your jaw drop, stories of families torn apart by greed, secrets unearthed that shake foundations, and justice sometimes hanging by the thinnest thread. But few cases have ever hit me with the immediate, visceral shock I felt the day Sarah Jenkins walked into my office. Her story was a classic tale of betrayal, but with a twist so audacious, so brazenly illegal, it instantly became one of the most compelling and ultimately satisfying fights of my career. Picture this: a multi-million-dollar estate, built through decades of hard work and shrewd investments, completely hijacked. Not by a distant relative or a vengeful ex-spouse, but by a person who had, by all accounts, been welcomed into the family's trust. The weapon: a single, poorly executed forgery on a legal document that, if allowed to stand, would have rewritten an entire lifetime of legacy and left my client, a gentle, elderly woman, destitute. What was at stake wasn't just Sarah's inheritance, it was her father's memory, his final wishes, and her own peace of mind after a lifetime of quiet devotion. The emotional weight in my office that day was palpable, and I knew, in that gut-wrenching moment, that I had to take this case. Here's what you need to understand about wills and estates in California. Under California Probate Code, Paragraph 6110, for a will to be valid, it generally needs to be in writing, signed by the testator, the person making the will, and witnessed by at least two credible adults who understand they are witnessing a will and sign it in the testator's presence. This framework is designed to ensure that a person's final wishes are accurately recorded and that they are not coerced or tricked. However, when there's a suspicion of fraud or forgery, the legal landscape shifts dramatically. California Probate Code, Paragraph 8252, specifically allows for a will to be contested if it was procured by fraud, duress, menace, or undue influence, which includes forgery. Essentially, if a signature is proven to be fake, the entire document it purports to validate becomes null and void. The law provides a mechanism for challenging the authenticity of a will, placing the burden on the challenger, my client, Sarah, to prove that the document doesn't reflect the true intent or even the true signature of the deceased. It sounds simple, but proving a negative, especially when facing a determined adversary, is anything but. This case wasn't just about a signature. It was about the very integrity of the legal system that safeguards our deepest desires for our families after we're gone. My client, Sarah Jenkins, was a woman who, at 72, carried the quiet dignity of a retired elementary school teacher, her silver hair neatly pinned, her eyes, though kind, now clouded with an unbearable sorrow. She sat across from me, her hands clasped tightly, telling me about her father, Arthur Jenkins. Arthur, she explained, had been a pillar of the Los Angeles real estate community for decades, shrewd, successful, and fiercely protective of his family. He had built an empire worth roughly $8 million, a fortune he always intended for his only daughter, Sarah. Their relationship was close, marked by Sunday dinners and phone calls every other day. Arthur had always been meticulous with his affairs. His last will, drafted 5 years prior, explicitly left his entire estate to Sarah, with a small trust for a local animal shelter he adored. This was his established plan, clear as day. Then, Arthur's health began to decline rapidly in early 2022. He was diagnosed with advanced Alzheimer's. Sarah, who lived out of state, moved back to Los Angeles to care for him, but Arthur, ever independent, insisted on staying in his own home with additional professional help. That's where Maria Garcia entered their lives. Maria presented herself as a compassionate, experienced live-in caregiver, highly recommended by an agency that later turned out to be less reputable than it seemed. Sarah felt uneasy about Maria from the start. A little too slick, a little too eager, but Arthur, in his declining state, seemed to bond with her. Maria slowly began to isolate Arthur, limiting Sarah's visits and phone calls, claiming her father needed rest. Arthur passed away peacefully in June of 2022. Sarah, heartbroken, began to sort through his affairs. That's when Maria Garcia dropped the bombshell. Just a few weeks after Arthur's passing, Maria produced a new will, supposedly signed by Arthur only a month before his death, a month when his doctors confirmed his cognitive abilities were severely compromised. This new will left a staggering 90% of Arthur's $8 million estate to Maria Garcia and a mere 10% to Sarah. Sarah confronted Maria in August 2022, but Maria was dismissive, almost smug, holding up the document as undeniable proof. Sarah was devastated, confused, and felt utterly betrayed. She had dedicated her life to her father, and now, not only was he gone, but his legacy, her security, had been snatched away by a stranger. She came to me in September, a fragile woman on the verge of losing everything, and I saw a quiet strength beneath her grief, a determination to fight for her father's true wishes. I knew I had to help her. The investigation phase was where we really had to roll up our sleeves. My first step was to secure every possible document: Arthur's original will, Maria's newly presented will, all medical records from the last 6 months of Arthur's life, and any financial statements we could get our hands on. The medical records quickly became a key pillar of our case. They painted a clear picture of Arthur's severe cognitive decline, making it highly improbable he had the testamentary capacity to understand, let alone sign, a complex legal document like a will. I immediately brought in Dr. Eleanor Vance, a highly respected forensic document examiner known for her meticulous work in complex fraud cases. She'd worked with me before, and I trusted her implicitly. Simultaneously, I hired a private investigator, a former LAPD detective named Mark Jennings, to dig deep into Maria Garcia's background and her activities leading up to Arthur's death. Mark's job was to find anything that would expose her true intentions and any collaborators. Our work was slow and painstaking. Maria Garcia, through her attorney, Kenneth "Ken" Harding, a shark known for his aggressive, often ruthless tactics, was completely uncooperative. Harding was a formidable opponent, his reputation for winning, even with weak facts, preceding him. He immediately pushed back on all our discovery requests, forcing us to go to court for motions to compel, which added months to the timeline. We subpoenaed Arthur's bank records and phone logs. Initially, the bank statements didn't show any glaring red flags of huge, unexplained transfers to Maria. It seemed she was sly. However, Mark's investigation into Maria started yielding fruit. He found that Maria had a history of short-term employment, often with elderly clients, and a few concerning incidents involving missing valuables, though nothing that had ever led to charges. More importantly, he traced the witnesses to the new will. 2 individuals, a man named Ricky and a woman named Brenda, both with prior misdemeanor convictions for petty fraud and shoplifting. Not exactly the kind of credible, unbiased witnesses you'd want for a multi-million-dollar estate. Then came the medical records. I spent countless hours poring over Arthur's doctor's notes, nurses' observations, and diagnostic reports. They detailed a rapid deterioration of his executive functions, severe memory loss, and moments of extreme confusion around the time the new will was supposedly signed. His primary physician explicitly stated in a progress note from 2 weeks before the alleged signing that Arthur was no longer capable of making complex financial decisions. This was vital. While Maria's attorney would try to argue Arthur had lucid moments, the sheer weight of medical evidence made that claim almost impossible to sustain. Dr. Vance, meanwhile, was meticulously comparing Arthur's signature on the new will to dozens of authentic signatures from checks, previous legal documents, and even credit card slips from the years prior. Her initial findings were intriguing, but not yet a smoking gun. She noted some consistencies that might suggest a skilled attempt at imitation, but also subtle inconsistencies that hinted at something darker. We were building our case brick by brick, facing dead ends and evasive responses, but my gut told me we were getting closer. The breakthrough moment arrived on a Tuesday afternoon. I was in my office, buried under a mountain of documents, when an email from Dr. Vance landed in my inbox. The subject line read, "Jenkins Estate, Final Report." My heart pounded a little faster as I opened the attachment. Dr. Vance had spent weeks meticulously analyzing every stroke, every curve, every tiny tremor in Arthur's signatures. Her report was detailed, clinical, and devastating. She had found it. The smoking gun. Arthur Jenkins, throughout his life, had a distinctive tremor in his right hand, a subtle but consistent pattern that appeared in all his authentic signatures, especially in the final flourish of his last name. Dr. Vance had identified this tremor, almost like a fingerprint, in every one of his known signatures. However, on the signature present on Maria Garcia's will, that specific tremor pattern was conspicuously absent. Instead, she detected what she termed hesitations and unnatural pen lifts. Tiny, almost imperceptible pauses in the stroke where a hand might lift slightly from the paper, typical of someone slowly and deliberately tracing or copying a signature, rather than writing it naturally. But it wasn't just the absence of a tremor, it was the presence of an inconsistent tremor. She also cross-referenced the signature on the contested will with the doctor's consent form Arthur had signed just 3 days after the alleged will signing. On the consent form, Arthur's signature was noticeably weaker, almost illegible, bearing the unmistakable signs of his advanced illness and the characteristic tremor. The signature on Maria's will, by contrast, was firmer, almost too perfect in its imitation, lacking the organic decline evident in Arthur's true handwriting at that time. "Mr. Miller," she wrote in her summary, "it is my professional opinion, with a high degree of certainty, that the signature purporting to be Arthur Jenkins on the June 12, 2022 will is a forgery." I reread that sentence 3 times. My stomach dropped, then soared. This wasn't just speculation. This was scientific proof. The air went out of the room for a moment as the full weight of her findings settled in. This evidence was legally significant because it didn't just suggest fraud, it proven forgery, rendering the entire will illegitimate and invalid under California law. I immediately called Sarah. She answered on the second ring, her voice tight with anxiety. "Sarah," I began, trying to keep my own excitement in check, "we have it. Dr. Vance has confirmed that the signature on that will is not your father's. It's a forgery." There was a beat of silence on the line, then I heard a small gasp, followed by quiet, deep sobs. They weren't tears of sadness, but of immense relief, of vindication. "Thank God, David," she choked out. "Thank God. My father. His memory. It means everything." In that moment, the years of experience, the long hours, the legal battles, it all coalesced into a profound sense of purpose. We were going to win. The courtroom drama was exactly what you'd expect when millions of dollars and a family's legacy are on the line. The Los Angeles Superior Court, Probate Division, was packed. Every seat was taken, mostly by other attorneys, reporters, and curious members of the public drawn to the salacious details of an estate battle. The air crackled with tension as Judge Evelyn Reed, a stern but fair arbiter with a reputation for sharp legal intellect, took her seat. I remember the smell of polished wood and stale coffee, the low hum of conversation before the gavel fell, bringing silence. My star witness, Dr. Eleanor Vance, took the stand first. She was a picture of calm professionalism. She presented her findings with scientific precision, using enlarged exhibits of Arthur's signatures. She walked the court through the distinct tremor patterns, the telltale hesitations, the unnatural pen lifts. She showed, side by side, the forged signature and Arthur's true signatures from the same period, highlighting the dramatic inconsistencies. "Your Honor," she concluded, pointing to the projection of the 2 signatures, "the differences are not merely subtle, they are diagnostic of a non-natural origin for the signature on the contested will." Ken Harding, Maria's attorney, launched into his cross-examination, trying every trick in the book to discredit Dr. Vance. "Dr. Vance, isn't it true that handwriting analysis isn't an exact science? Isn't there a degree of subjectivity involved?" he boomed, attempting to cast doubt. Dr. Vance, unruffled, replied, "Mr. Harding, while no science is exact, in the way mathematics is, forensic document examination employs established scientific principles and methodologies. My conclusions are based on empirical evidence and comparative analysis, not subjective interpretation." He pressed further, "Could it not be argued that Mr. Jenkins simply had a very good day when he signed this will, and his tremor was less pronounced?" "Unlikely, given the medical records of his advanced neurological condition," Dr. Vance stated firmly. "Moreover, the specific pen lifts and hesitations observed are not consistent with a naturally executed signature from someone with a tremor, regardless of a good day. They are consistent with an individual slowly and carefully replicating a signature." Harding eventually sat down, having failed to significantly shake her testimony. Then it was time for Maria Garcia's testimony. She had a practiced, almost angelic demeanor, claiming deep affection for Arthur and portraying Sarah as an absentee daughter. I approached her, my voice calm but firm. "Ms. Garcia, you testified earlier that Mr. Jenkins was sharp as a tack when he signed this will, correct?" "Yes," she replied, her voice soft. "He had his moments, of course, but he knew exactly what he was doing." And yet, Ms. Garcia, his medical records from that very week, provided by his own physician, indicate severe, irreversible cognitive decline, explicit memory impairment, and a clinical diagnosis of advanced Alzheimer's. How do you reconcile your testimony with these official medical records?" She faltered. I don't know. He seemed fine to me. He trusted me." I leaned in slightly. "Did you arrange for the witnesses to this will, Ms. Garcia?" "Yes, I did," she said, regaining a bit of her composure. "They were friends of mine who were there to help. Did you know that both of your friends, Mr. Ricky Moreno and Ms. Brenda Jones, have prior convictions for fraud and grand larceny?" Her composure visibly cracked. She hesitated, her eyes darting to Ken Harding, who quickly rose with an objection. "Objection, Your Honor. Character evidence, irrelevant." Judge Reed, however, calmly stated, "Overruled. Goes to witness credibility and potential complicity. Ms. Garcia, you may answer." Maria squirmed. I was not fully aware of their past." "Did you pay them for their services that day, Ms. Garcia?" I pressed. She gulped. "It was a small thank-you fee for their time. A small thank-you fee for witnessing a forged will that would grant her millions." The silence in the courtroom was deafening. I then presented the enlarged Dr. Vance's exhibits, projecting the undeniable evidence of the forgery for the entire courtroom to see. The contrast was stark, damning. Maria's face drained of color, turning a ghastly white. Ken Harding, for all his bluster, looked utterly defeated, his shoulders slumping as he stared at the projections. The game was up. The truth in black and white, or rather in ink and paper analysis, was irrefutable. The judge's ruling came swiftly, decisively, and without a shred of ambiguity. Judge Evelyn Reed declared the purported will of June 12, 2022, invalid on two crucial grounds: outright forgery and Arthur Jenkins' undeniable lack of testamentary capacity at the time of its alleged signing. She cited Dr. Vance's expert testimony as particularly compelling, highlighting the detailed forensic analysis of the signature discrepancies. The original will, drafted 5 years prior, which left Arthur's entire $8 million estate to his daughter, Sarah Jenkins, was immediately reinstated. Justice had prevailed. The specific outcome meant that Sarah would inherit her father's entire estate, ensuring her financial security and honoring Arthur's true intentions. Maria Garcia's claim was dismissed entirely. More than that, Judge Reed, recognizing the egregious nature of the fraud and elder abuse, took the extraordinary step of referring the case to the Los Angeles District Attorney's Office for potential criminal prosecution against Maria Garcia for elder fraud and forgery. The look on Maria's face as the judge delivered that part of her ruling was one of pure, unadulterated terror. Sarah, sitting beside me, squeezed my hand tightly, tears streaming down her face. Tears not of sorrow, but of profound relief and gratitude. We had done it. Within weeks, the district attorney's office announced they were indeed pursuing charges against Maria Garcia. The wheels of criminal justice had begun to turn. This case, like so many others, left an indelible mark on me. Here's what I learned. The depths of human desperation and greed are boundless. Maria Garcia, for all her calculated deception, ultimately fell victim to her own avarice, believing she could outsmart the system and manipulate a vulnerable man. It also underscored the critical importance of a robust estate plan and, crucially, the vigilance required to protect our elderly loved ones. The broader legal lesson for anyone watching is this: never assume a will, once signed, is foolproof, especially when dealing with complex family dynamics or the involvement of new, outside parties in an elder's life. Always be aware of the warning signs, sudden, unexplained changes in a will, particularly when an elder is experiencing cognitive decline. New, friends, or caregivers who isolate an elderly person from their family, and any unusual or significant financial transactions around the time of an estate plan change. My practical advice is this. Have frank conversations with your elderly loved ones about their wishes and their estate plans. Encourage them to review their wills periodically and make sure they have a trusted power of attorney and healthcare directive in place. Most importantly, if something feels off, if your gut tells you a situation isn't right, investigate immediately. Don't wait until it's too late. The cost of conflict in estate litigation is high, not just in dollars but in emotional toll, but the cost of inaction can be far greater. As for Sarah Jenkins, she's doing remarkably well now, months later. She's finally able to grieve her father properly without the weight of this legal battle hanging over her head. She's in the process of setting up a foundation in Arthur's name, dedicated to supporting Alzheimer's research and elder care, a fitting tribute to his memory and a testament to her strength. She even sent me a lovely Christmas card last year, a testament to the profound impact our work had on her life. I do this job because every now and then I get to witness true justice being served, to fight for the wronged, and to help people like Sarah find peace. If you've been touched by this story, or if you have questions about estate planning or elder fraud, drop your comments below. I read everyone. And remember, I've got plenty more stories like this one, tales of human drama and legal battles coming your way, so hit that subscribe button, and I'll see you in the next one.